Okay, welcome back. Everyone have a seat. All right. Ladies and gentlemen of the jury, we are now ready to proceed forward with the final argument of the attorneys and state. You may proceed.
This is Felicia Nicole Williams. She was a daughter. She was a sister. She was a cousin, a classmate, an aunt. She sang in her church choir. She liked to go feed the ducks at the pond. She liked to ride her bikes. On Saturday mornings, she liked to go to the Little League field at Belmont Heights and watch the games. She was 9 years old. She was in 3rd grade at Edison Elementary. That's all you get in this case about her. That's it. In this penalty phase, this little snapshot that you heard from Ms. Emerson, that's all you get about Felicia. You don't get a professional documentary like you got about the defendant. You don't get to hear from her family members. You don't get to hear from her friends about the good qualities. We heard a few from Ms. Emerson. How she's an old soul, how she never met a stranger. We heard a few little things. I think we probably all know by now. This little kid had quite a personality. But it's a snapshot. That's all we get of little Felicia. We don't get a high-tech, glossy film her friends in her house. You didn't get to see the inside of her house. You didn't get to see the conditions on Ida Street in East Tampa, which is a pretty rough neighborhood here in Tampa. What we did hear about little Felicia is that on May 16 of 2014, she was 9 years old, that she happily trotted through that door into an apartment that, as we've seen, was a very Spartan apartment, carpeting, stucco walls, a couch, sliders. Probably all of us have lived in an apartment like that. We may even live in one like that now. Just an apartment. But for Felicia, through that door was terror. Through that door was fear. Through that door was pain. And through that door was suffering. Suffering. Tremendous amounts of suffering. She wasn't shot. She wasn't stabbed. Her life wasn't taken quickly. This was prolonged. This was on for minutes and minutes and minutes. Because that's the way this defendant wanted it to be. That's the way he committed this one. This was up close and personal. This was killing someone with his bare hands. In this case, there are multiple aggravating factors that are statutorily defined. The state is restricted to the Florida statutes and our aggravators. Unlike the defense, you can present almost anything as mitigation. In fact, you will hear And the instructions to you, and I don't disagree with this at all. I don't debate it at all. And I wouldn't. But you will hear that the existence of any other factors in his character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty or possible mitigators. You will hear a list of mitigating circumstances that are being suggested to you. We're going to discuss that in these closing statements. But we are restricted to simply 3 aggravating circumstances, statutory factors. Again, I don't argue with that. There are 11, including that character, background, or life or circumstances mitigation, mitigator. There are 11 mitigating circumstances. There's only 3 aggravating factors. But we know, and you will be told in these instructions, and you heard it back in jury selection, this is not a mechanical process. This is a process of weighing and assessing quality, weight of this evidence. One aggravating factor, if proven to you beyond a reasonable doubt, if you find its weight is significant enough, that the gravity that it increases the crime to is significant enough, it can outweigh all of that suggested mitigation, some of it which I will suggest to you has not been proven by the greater weight of the evidence, some of which we all know wasn't proven at all. It doesn't exist in this penalty phase evidence you've heard. Two of our 3 aggravators were proven to you by your verdict, as Ms. Johnson told you. Felicia was under 12. That's been proven to you beyond any doubt necessarily by your verdict, your unanimous verdict, that she was under 12 when she was raped. You've also found that this defendant was guilty of felony murder based on capital sexual battery, a murder that occurred during the course and commission of a rape of a little girl. That's an aggravating circumstances during the course and commission of a capital sexual battery committed or murder. Those 2 aggravating circumstances have been proven to you by your verdict. You have found that they have been proven to you beyond a reasonable doubt. And as I told you in my closings, beyond any doubt, he's death eligible. That means he's death eligible. So that first hurdle, we've already stepped over that. At least one aggravator has been proven to you. I will talk to you about the 3rd shortly. Now the process for you is looking at how much significance you personally want to give to these aggravating circumstances. How much weight you want to assign to them. You have to determine if the aggravating circumstances that have been proven, and like we've said, 2 of them have been proven by your verdict, you found that, whether they outweigh this mitigation. I would suggest to you they do. And then you have to decide whether they would justify an imposition of death. A child under the age of 12. Let's talk about that. Why is that an aggravating factor? Why is Felicia's age an aggravating factor? Why is being 9 years old an aggravating factor? A society is judged by how it treats its children. It is absolutely judged in that manner. And it's been that way for thousands of years. And they are the most precious, the most helpless, the most vulnerable of all our citizens in our society. They're small, they're weak, they're dependent. They're dependent on us as adults. They're undeveloped, physically and mentally undeveloped. They don't have the ability to care for themselves and have to be cared for. They are necessarily needing of protection. Societies around the world for hundreds and hundreds and thousands of years have protected their children. Our society does that. Our country does that. Our state, our cities, our counties. Not just government institutions. We do that. All of us do that. We protect our children. As families, as communities, as neighbors. It was interesting to me that Ms. Redley talked about in Jamaica that neighbors spank their neighbors' children if they were naughty. That's going back, isn't it? That's old school. That's something I remember from when I was a kid. And that's part of protecting our children, is punishing them when they do wrong, and making sure they understand the difference between what's right and wrong. But we also have organizations like DCF, Department of Children and Families. We have government assistance for young mothers that can't support their children. Every way in this society, we take care of our children. They're the weakest and most vulnerable. That's why they're different under the law. That's why they're different, and of course they are. They're different. They hold a special value and a special place as far as protection under the law. In all due respect, a couple of weeks ago when we were selecting our jury, there were a couple of jurors when we were talking about the fact the victim was a child, who I believe said something along the lines of, that wouldn't matter to me because her life is just as valuable as an adult's just as valuable as hers. And that's true, it is. But it does matter that it's a child. It's an aggravating factor because it increases the gravity of the crime. Children, as I said earlier, have a special kind of fear. It's a fear based on the imagination of children. A tremendous amount of it's based on their innocence and their vulnerability. You know, the way a child wakes up with a nightmare, runs down the hall, jumps into his parents' bed, or hides behind their parents' legs at some carnival, scare house, or something frightens them, something startles them. This crime would have been a horrible, horrible crime if it happened to an adult. It would have been a horribly brutal crime, and it would have been a crime where the death penalty would have been appropriate with an adult. With an adult. If this had been a woman who had been raped and violated and strangled in this manner. She was a child. She was vulnerable and needing a protection, which is obvious from this case. And once her protector left her, this defendant, well, we saw what happened to this little girl. She lost that protection that our society provides little ones. She had no chance against this man. Dr. Downs told us about the relative sizes. We all know that. We didn't need to tell us that. Men are bigger than women on average. Men are stronger than women on average. But against a child, a 9-year-old little girl, against a 35-year-old man, 5'9", 170 pounds, there's no contest in that situation. Children are different under the law. And they're special for one other huge reason that I've already mentioned. Their innocence. Their innocence. Because they're living in that time, which is a very short time, with respect to the rest of our lives. We're only children once. It's a very magical time, hopefully a very good time for children, where they can enjoy their childhood, they can maintain their innocence. That carefree nature, where they don't have the troubles and the worries of the world that we all carry on our shoulders as adults. We carry that for them. Hopefully, they don't get pushed into growing up too fast. But it's the innocence of children, really, that separates them from the rest of us. We take the brunt, not them. We take that for them, so that they can have that childhood life. Because life's tough. Life will saw you in half if you let it. This little girl being under the age of 12 is an aggravating circumstance, or aggravating factor, as it's termed in the law. It increases the gravity, and it increases it in a manifold way. It's an exponential increase. It's not just a step up. We're talking about multiple steps of significance. Because we go from an adult to this small child who is incapable of defending herself. It is a night and day difference between the two. We know in this case, Dr. Lazaro talked about it at length, how this defendant preyed on the vulnerable, on the brokenhearted, on the young, on the drug addicted or people who use drugs, on those with low self-esteem. He picked and he chose his victims. And he did that by using his very well-developed executive problem-solving, reasoning abilities. In her opening statement, Ms. Johnson referred to HAC, or H-A-C. It's an acronym in the law that stands for heinous, atrocious, and cruel. This is an aggravating factor that you will have to now consider from both the evidence you heard in the guilt phase and the evidence you've heard in the penalty phase, especially the testimony of Dr. Downs, who came back down here from Georgia to talk to you, to talk to all of us in this courtroom about what this little girl went through. Because when you were deciding whether this defendant was guilty, because living in this country, like all of us, he enjoys the benefits of due process of law and the constitutional protections afforded to all of us. One of those is a due process mandate under the 14th Amendment of our Constitution. It means we can't present evidence of things such as suffering when it comes to guilt or whether he's not guilty. Because you didn't really consider his innocence. You were considering whether we've proven our case beyond a reasonable doubt, which is another constitutional right that this defendant enjoyed because he came to this country several years ago from his home country. But now you can consider it, because now you're considering what's the appropriate penalty for what happened to this little girl. So we brought Dr. Downs back down here to tell you what she went through. We all know what she went through. That became a torture chamber for this little girl. A torture chamber for this little girl. Let me say that again. Torture. Because that's what Dr. Downs said that the medical journals equate strangulation to. Torture. What this little girl went through in the last minutes of her short little life was torture. This was an extremely heinous crime. It was atrocious what he did to her. But out of the three, I would suggest cruelness fits this crime like a glove, which I believe Dr. Wu used as a metaphor. They fit it like a glove. She suffered from the cruelness of this defendant. She suffered, and you will read in the instruction as to what heinous, atrocious, and cruel is. Lack of mercy, pitilessness, and the commission of a crime are all definitions of heinous, atrocious, and cruel. There was no pity for Felicia Williams in this defendant's heart that day when he had her alone. All there was in this defendant's heart was his selfish, perverted desires to have sex with a little kid. And because he wanted to do that, because that was so important to him, following right along with the diagnosis that Dr. Lazzaro just told you, antisocial personality disorder, he put himself before her. He put his perversions before her. And ultimately, his lust and his perverted desire was the price that he put on her life. That shows you how atrocious and cruel this case was. But we know there's a lot more to it than that. We know it drove this crime. We know it drove his manipulation and his deceit. It drove the charade that he pulled on Ebony Wiley, this con game, conning her out of this little girl's life. And the steps that he took to do that, which also demonstrate to you that he suffers from no cognitive impairments that was from love, folks. This was a multi-step process. He had to convince her that he wanted to be involved in helping. Then he went and picked her up, and instead of going to McDonald's, he beelined right to his mother's apartment at Temple Terrace, knowing all along he was going to get rid of Ebony at some point so he could get his hands on this little girl. Instead of going to a sit-down restaurant, they went to a drive-thru. He tried to take him directly to the apartment, but he had to feed her. Ebony stood up for her and said, "You need to get her something to eat." They went to Checkers. His perverted desire drove him through all of those multiple steps of deceitfulness, slipping her drugs, all the things we've talked about. That shows you how premeditated this murder was. But it also shows you how heinous and atrocious this murder was. Because it was his lust and perversion that drove it, his ultimate goal to violate this child, that drove what he did to her. The process of manual strangulation, killing someone with your hands, it's not an easy task. It's not easy to kill another human being, even a little girl, with bare hands, with no weapon, just your bare hands. It takes brutality and it takes time. It's equated to waterboarding. The effect it had on her, the mental effect, the mental anguish. Think about that. To waterboarding, simulating drowning. So in effect, this little girl was tortured to death. The panic that she experienced, the air hunger that she experienced, when that word, the dread. The dread. That's a word we don't use very much. Sometimes we dread things in our lives that are unpleasant. Can you imagine the dread of knowing that your life is ending? And you're feeling pain all over your body as it's bleeding internally from all of these injuries. The pain and suffering of feeling penetration, feeling the tearing and ripping of sensitive tissue in her genitalia as he penetrated her, as far as we know, over and over. We have no reason to believe he didn't do that. And that pain would have been exponentially greater for a little girl, a little innocent girl. And then the pain of his hands compressing her neck, and the structures of her neck, to cause all that internal hemorrhaging and all those injuries to her muscles, all the way down to the longest muscle, which Dr. Downs told us, that indicates to him she was struggling. She was writhing in pain and moving around and trying to get away from it. And the internal injuries to that neck show that. They show that this little girl was resisting as much as she could his vice-like grip on her throat. And in that struggle, biting her tongue. And not just the kind of biting that someone would do by chewing food and accidentally biting your tongue, like a lot of times we do when we're so hungry, we're eating fast. Dr. Downs told us, no, it was worse than that. It was a deep, deep hemorrhage in her tongue. From either her chin hitting something or his hands pushing up on her neck and pushing her tongue up into her teeth. And her biting. Because she was struggling and not paying attention. She was only trying to live. And then we know he beat her. He either hit her in the head when she recovered at some point, or he hit her in the head or smashed her head into the ground at some point when he was putting her on the ground. This isn't pleasant to think about. It isn't pleasant. It's not natural to sit here and think about this and walk through this. This is ugly. This is nastiness. But you have to think about this because you are considering what his penalty should be. And to ultimately to be able to do that in an honest and a fair and a just manner, you have to consider what this little girl suffered and what she went through. Remember this when you're back there deliberating. Remember this when the idea of mercy maybe starts to percolate up a little bit into your mind. Remember that during these several minutes, at least 3 minutes to inflict all of these injuries to her body, remember there was never, not for 1 second, relief for this little girl. She never had relief during this. She was suffering an excruciating pain from here to the top of her head, from her genitals all the way up. There was nothing that wasn't unpleasant, painful about this murder. He absolutely brutalized her. What this little girl endured, no child should ever have to go through. She suffered an agonizing death. This isn't a very efficient way of killing. But none of that stopped this defendant. You can consider that when you're considering whether we have proven whether this was heinous, atrocious, cruel, or torturous. Because you can consider, like I said earlier, whether he exerted any mercy at all to her, any pity to her. The last thing she did before this was to sit on that couch. Maybe her legs were hanging off the side of the couch, eating shrimp and fries and drinking her Sprite. Her godmother was there, a woman she'd gone to church with, gone on bike rides with, gone to the park with, ate at restaurants with, just as carefree as could be. And just within minutes, she's in the middle of this horrible, horrible death. And this new place she had never been before was the last thing she saw, other than this defendant's eyes as he was strangling her to death, because certainly she was looking into his eyes. At some point we know he grabbed her. Whether it slammed her to the ground and caused that injury to her back and the bruises to her shoulders, we don't know. Maybe it was just from the pressure of him leaning up on top of her, pushing down on her shoulders, pinning her as he raped her. Either way, we know it caused a lot of pain and a lot of internal bleeding. There's no doubt in this evidence that this defendant had absolute control over whether she died or not, whether she lived, whether she died, how long this went on for. It was all in his hands. It literally in his hands. As he squeezed on her neck with that vice-like grip, and compressed her jugular vein, and the blood was going into her brain and it was backing up. The brain was utilizing, like we talked about in closing statements a couple days ago, using up the oxygen molecules in her blood, and no fresh oxygenated blood could get to her brain. She would have started to fade out and lose consciousness. We know that happened from all of the bloody petechial hemorrhages in her eyes. And once her brain had used all that oxygen and exhausted it, and she had passed out and fell unconscious, the level of vulnerability of not just being a child, but now it's gone up again exponentially, because now she's just laying there on the ground while he compresses her neck and squeezes on her neck. She's laying there basically asleep, unconscious, completely helpless to a very high degree. You can't get any more helpless than that. She's basically laying there not moving, inanimate, not struggling anymore. Just this little girl laying there. And he's still compressing her neck, still strangling her with that vice-like grip. And we know from Dr. Downs this could have taken minutes, several minutes. If for some reason he thought, well, now she's dead, and he let go, she would have regained consciousness and started to wake up, and he would have had to apply it again. We don't know how many times that happened. It could have happened multiple times. And as she came to, if that did happen, she would have been waking up to this horror, waking up to this suffering and the pain, waking up to this every time that happened. And as I said, you are entitled to think about not just what she was going through, which was horrific. You're entitled to think about how he was doing this and what was going through his mind and what the evidence proves was going through his mind. Because during all of these seconds, and you remember, we did that in closing statements, we took that minute. And you remember how excruciatingly and uncomfortably long 1 minute was. Well, I want to go back to that minute. I'm not going to do a quiet minute again with you. But I want to talk about that minute. Because, we use that term a lot. Give me a minute. Let's take a minute. It'll only take a minute. We don't really think about that term. But when this little girl's laying there unconscious and he's squeezing her neck and continuing to do what Dr. Downs told us physiologically had to have occurred. This isn't guesswork. This is science. We know this is how she died. He is squeezing her neck and cutting off her jugular vein, preventing oxygenated blood going to her brain, and continuing to do that while the brain's using the oxygen and she gets close to death, and had to continue to do it for minute by minute by minute until she died, until she lost her life. So I want you to think about this again when you're back there deliberating, when you're considering whether you should give him life, and considering whether you should personally extend mercy to this defendant. Did he extend mercy to this little girl? Because in the heinous, atrocious, and cruel instruction, it says...
Objection, may we approach it?
Yes?
When you're considering whether the state has proven the aggravating factor of heinous, atrocious, and cruel, you can consider whether the defendant extended mercy to her. You can consider how pitiless the crime was. And during all of that time that he's compressing her neck, as Dr. Downs says, it takes seconds and minutes. Each one of those seconds was an opportunity for this defendant to show mercy and to let her live. Each one of those seconds was an opportunity for him to show pity on this little girl. And he showed no pity. This was a merciless, pitiless murder. There's no doubt about that. He showed no mercy to her. Does it get any worse for a child? Does it get any worse to die in this way for a little girl? This aggravating factor alone, heinous, atrocious, and cruel, which we have proven to you in the penalty phase, it's not inherent to your verdict. We've proven this to you now in the penalty phase beyond any doubt. This aggravating factor alone stands in its power, and it stands in its veracity, and it outweighs any mitigation presented to you. This aggravating factor alone justifies a sentence of death. This aggravating factor alone justifies a sentence of death. We don't even have to look at the other two. But of course, as I stated to you earlier, you've already found we've proven the other two beyond a reasonable doubt. So there is no doubt. All the aggravating factors in this case have been proven to you beyond any doubt. Your next step in deliberation is to determine, do these aggravating factors justify a sentence of death? And clearly, combination, altogether, they clearly do. Absolutely they do. Do they outweigh the mitigation in this case? There's no question that they outweigh the mitigation in this case. But as to HAC, heinous, atrocious, and cruel, the atrocious, cruel killing of a little girl, the gravity of this aggravator, because it does increase the gravity of this murder, this alone justifies a sentence of death. I want to talk to you now about the suggested mitigation in this case. So I want to discuss these with you. We can go through them. There's several. I hope you all can see those. The capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired, meaning mentally impaired. He suffered from a significant head injury as a child but received no medication and has continued to have migraines afterwards. Is there any evidence of that? Is there any evidence that proves that? Any reliable evidence other than this defendant's statement that he slipped and fell on a surface that he couldn't identify for Dr. Eisenstein, who he now tells Dr. Lazaro after hearing Eisenstein's testimony yesterday that he couldn't identify the surface, that of course it's like the hardest surface it could be, concrete. No evidence that he suffered from any kind of head injury, no evidence that he blacked out, that he was unconscious, that he had a concussion, that he went to the hospital, none. Mr. Ritchie suffered mental and physical abuse by his father. That was definitely proven by the greater weight of the evidence in this case, because that's their only proof. They don't have to prove it beyond a reasonable doubt. I'll talk about that in a minute, but I would suggest to you that that's been proven by that standard. Not beyond a reasonable doubt, but they don't have to prove it beyond a reasonable doubt. Was he raised in a poverty-stricken and violent neighborhood in Kingston, Jamaica? Yeah, apparently he was. But you know what we heard? We heard from Miss Redley that it wasn't that bad when they were growing up in their generation. It's gotten worse. So all the video, all the photos you saw are the way it is now, not the way it was then. But it sounds like, yeah, it was a violent neighborhood and it was poverty-stricken. But you know what else we found out, thanks to her testimony? That there's a lot more dynamics involved in this case than what we heard on that video. there was a lot more dynamics to this case, and I will talk about that video, all right? Because you didn't just get to see a video about Felicia. You got to see this video about the defendant with all these people who know him. I want you to think about every other witness who testified in this case that had to come in here before you could hear them and be sworn under oath and be subject to cross-examination. And how many times in this case have you seen facts revealed in cross-examination that were never brought up in direct examination, like Dr. Anderson failing his board certification examination, and Dr. Anderson not wanting to answer any of my questions, not wanting to be confronted with the circumstances the victim was found in. None of these people from this video were subjected to cross-examination by me or Ms. Johnson. Neither of them, none of them, not one of them was subjected to cross-examination about what their potential biases would be, their potential motives would be, what their past is, what their relationship is to the defendant, other than a little blurb up there. None of them were subjected to the testing, the due process testing that this defendant was able to receive all through this trial. We didn't get that. We weren't afforded that. We didn't get an opportunity, and you didn't get an opportunity to hear what we may have asked them and what they may have told us if we had cross-examined them. You got a light, most favorable to the defendant version of facts about him. Now, I'm not going to sit up here and tell you that where he grew up in the Garrison in Kingston, Jamaica, is some upscale neighborhood. It clearly is not. It clearly is not. We have neighborhoods like that here in this country. Like Ms. Redley told us, they're called ghettos. They're called slums. We have high crime areas like Ida Street, where Felicia lived. We also heard from Ms. Redley, not from the video, about the fact that the defendant, although he was abusive to the children and apparently to his wife in front of them, that he held a status. That there was this political situation where politicians would go into these neighborhoods to garner votes, and they would pay these community leaders money, and these community leaders had status that went by birthright to this defendant as the firstborn. So he was raised in a status and privileged position as the son of the Don or Dan of that garrison. He enjoyed that privilege. You saw a bunch of really, not horrible, but kind of rundown neighborhoods, but then you see this beautiful high school that he went to. Did you see that? It kind of flash up there on the video real fast and off. Just a real quick photograph of that high school where he went, that he had to make good grades to get into, like Dr. Lazaro told us, but Ms. Redley told us also his privilege helped him get into that school. This defendant was raised with privilege. This defendant was able to get a GED or equivalent of a high school diploma. And then we know this defendant was able to immigrate to this country. I believe the one lady in the video called it migrating. He immigrated here to this country years ago. And as he lived here, he enjoyed the benefits of this country we live in. That's the greatest country on the face of the earth. He enjoyed all these benefits we've talked about. He enjoyed the due process rights that we talked about. He enjoyed the fact that we carry the burden of proof to prove his guilt, that he's presumed innocent, that he's entitled to a jury of his peers, to not just determine whether he's guilty or not, but a jury of his peers to determine the appropriate sentence. Because this isn't Jamaica or some other country. This is the United States, where this defendant gets to have you determine his sentence. Not some bureaucrat, not some single judge, not some single person, not some star chamber, but you, his fellow citizens. He's enjoyed all of these benefits. He's enjoyed the benefit of a neutral and unbiased judge. He's enjoyed the benefit of competent, very competent defense counsel during this case. So we know he was able to pull himself up out of that situation. Move here, where he had all these opportunities in this country. And we saw how he took advantage of those opportunities. He took advantage of them by manipulating all these women in his life for car, for money, how he hadn't worked for months, but how he was still able to live a fairly good life. And in fact, we've seen through his manipulation and the intelligence he has to do that Dr. Lazaro talked about, that over the last 5 years he's gained all this weight because he's manipulated Calissa Kelly, who we found out, you know, she is his girlfriend, even though she didn't want to tell us that. How about that? That she has been putting money into his canteen, which she didn't want to talk about really, for 5 years, and allowed him to gain all this weight, and made it comfortable for him in the jail while he waited for his trial. You really think that would happen in Jamaica? You think that would happen in the countries of the Caribbean? It happens here in this country because he enjoyed all those rights, the constitutional rights. He enjoyed what Mr. Land talked about, the prison expert yesterday, who was an expert in the quality control and treatment of inmates in prisons and jails, and that's all he's an expert. He's not a mind reader. He's not a predictor of future behavior or activity. He's not a psychiatrist. But he told us inmates have to be treated well. If they're not, people like him join in lawsuits where they sue prisons and jails for maltreatment of prisoners. This defendant has enjoyed all of these things. You should consider all of that. Consider the fact that we didn't have an opportunity to question these witnesses, in particularity and specificity about his upbringing. Did he suffer at the hands of an abusive father? Yeah, he did. Absolutely he did. I think that's been proven to you. But now you need to determine the weight you want to give to that and whether the state's aggravating factors outweigh that. A lot of people have bad childhoods. A lot of people grow up in bad neighborhoods all over the world, and even in this country, all over the place. From the ghettos of Chicago to the Appalachian area up in West Virginia. There's a lot of poor folks in this country, people who live in poverty, that raise themselves up out of it. There was a young man many, many, many years ago that had an abusive alcoholic father who beat him unmercifully. A young man who would come home from school and find his dad passed out in the snow, and find his dad passed out on the couch. And when he became a teenager, there were times when he brought his girlfriend home, and he brought home his friends, and his dad would be raging drunk or passed out, either in the yard or inside the house, or would come in while they were there raging drunk. That young man was able to pull himself up to college, at Eureka College, and played football and baseball. And then later he became an actor. Not a real well-known actor, but an actor. Not too long after that, he was the president of the Screen Actors Guild in Hollywood. Not too long after that, he became the governor of California. And about a decade later, he became our 40th president. You may not have cared for the politics of Ronald Reagan, but everybody who knew him or saw him knew he was a gracious, kind man who grew up in that. And you don't have to look at extreme examples like that to know people pull themselves up out of this kind of childhood all the time. This defendant was living here in this country for many years. Sometimes he worked, sometimes he didn't. Going down the list, he was the oldest of 18 siblings and helped raise him. We heard some of that. That's probably true. He was gainfully employed at various jobs, such as a worker at the airport and with a Comtrans Communication, making cell phone towers. And we heard Dr. Lazaro talk to them and confirm what we all know and what we know from Dr. Holder, that Dr. Wu's testimony is weightless and should have no impact on your sentencing. There's absolutely no evidence this defendant suffers from any kind of brain impairment, any kind of cognitive disability. It's proven in the facts of this case, the facts of the murder itself, and the manipulation, the deceit, not only in the murder, but in the way this defendant manipulated an entire police department for 24 hours evading the police, destroying evidence, getting rid of Felicia's body, the lies and the deceit throughout his statement to the police, all of that shows cognitive functioning. You have to be able to think and think fast, like Dr. Lazzaro said. And we didn't need her to come in here and tell us that. We really didn't. But Dr. Holder told us that Dr. Wu's testimony is weightless because you can't use PET scans and MRIs to diagnose brain injury or cognitive dysfunction. That doesn't exist in clinical work. It just doesn't. He said maybe one day research is going on. The papers he's referring to, Dr. Wu was referring to in that long PowerPoint, were all research papers. I would suggest to you that his capacity to appreciate the criminality of his conduct or conform his conduct to the requirements of law was not substantially impaired. His ability to appreciate the criminality of his conduct. Really? Why do you think he insisted on fabricating and manipulating this lie between Ebony Wiley and his mother, a lie that stood in place for about 12 hours until Ebony caved? A lie that, as we talked about, went all the way down into Bradenton County, where his mother lied twice to the police at this defendant's insistence, and we saw in the evidence and the text messages downloaded from Ebony Wiley's phone how he coordinated the two. Contact Vivian now. How they all coordinated this. He clearly understood the criminality of his conduct. He clearly understood what he did was wrong. And he evaded the police because of that. That has not been proven by even the greater weight of the evidence. There's zero evidence of that. Granville Ritchie has a low risk of recidivism. Well, we heard Dr. Eisenstein say he did, based on this VRAG test, that Dr. Lazzaro told us she wouldn't rely upon. Dr. Lazzaro told us he has antisocial personality disorder, and he has a high risk of committing violent crimes in the future. That's not a mitigating circumstance. And he doesn't have a low risk of recidivism. Was he kind and generous to others and possess other positive redeeming qualities? Well, he bought Felicia some shrimp and French fries before he raped and murdered her. So I guess there is some kindness or quality there. And he apparently helped out some of these folks back in Jamaica, but again, we didn't get a chance to question them about the dynamics, the underlying bias they may have. That you will have to take into consideration when you're assessing how much weight to give to these mitigating circumstances. Some of which have been proven, a lot of them haven't. On the defendant as his primary historian. The defendant, the person who lied over and over and over, who was a master manipulator and liar in this case, who spun lies left and right throughout this case. Was he under the influence of extreme mental or emotional disturbance when he committed this murder? When he made all those deliberate, thoughtful actions in strangling her to death and ripping her clothes off to get to her so he could rape her? All of that takes thought, and all of that takes deliberate thoughtfulness. It takes problem solving. And then he had to figure out how to get rid of her body, stuffing her into some space in that apartment until Ebony Wiley, till he could get rid of her, delaying the police, all of that we've talked about. There's no evidence he was under the influence of extreme mental or emotional disturbance. That has not been proven to you at all and should be given zero weight. And I apologize for not seeing that earlier. It was on another piece of paper, but I wanted to talk to you about the verdict form. So, when you're considering the aggravating factors, victim is less than 12 years of age. We, the jury, unanimously find the state has proven beyond a reasonable doubt the existence of the aggravating factor. Victim is less than 12. That's an automatic yes, because we've already proven it. You've already found it in your verdict. The murder was committed while he was engaged in the commission of a sexual battery. That's an automatic yes, because you've already found that he was. And then the heinous, atrocious, and cruel, and an especially heinous, atrocious, or cruel. The state has proven that beyond any doubt, and that should be a yes. So in your verdict, those will be the first steps, like we talked about, to determine, have we proven our aggravators, and we have. Then you will have to determine whether, in reviewing the aggravating factors, you unanimously find to be established by a reasonable doubt that you have to unanimously find that they are sufficient to warrant a possible sentence of death, and I think clearly we've proven they are. So then you go to the next step, where one or more mitigating circumstances established by the greater weight of the evidence. That would be yes. Then you move on to Section D, eligibility. We find the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count one. That, I would argue to you, under this evidence has been established. Ultimately, this is where you will be left in this case. Having unanimously found that at least one aggravating factor has been established, we've proven three. That the aggravating factors are sufficient to warrant a sentence of death, and the aggravating factors outweigh the mitigating circumstances, we unanimously find that Granville Ritchie should be sentenced to death. And that's up to you individually to make that decision. You can deliberate on it, and don't let anybody try to convince you that you cannot discuss and deliberate on that subject of whether death is an appropriate sentence. It is a personal decision for you, but you can deliberate and discuss whether you believe that he should. Ultimately, you're going to have to vote as jurors to be unanimous, so you're going to have to discuss it. Let's talk about this last aggravating factor. The murder occurred during the course and commission of a capital sexual battery. And you can see how these aggravators all intertwined and dovetail. Because raping a child and murdering that child during the commission of that rape leads to the aggravating factor of heinous, atrocious, and cruel. When you're strangling a child while you're raping her, it's necessarily going to be cruel and atrocious, as we've discussed. This right here, well, I didn't put it up there. This, let me find the aggravating factor. Number 2 on your verdict form. It's committed while he was engaged in the commission of a sexual battery. Well, it's not just a sexual battery, it's a capital sexual battery. What I was going to do is point and say that's the glue in this case that holds this case together, like I told you in the closings. It's his motive. It's the whole reason for all of this. It's why he brought Ebony and Felicia there. It's why he got rid of Felicia or Ebony to get to this little girl. It's what motivated and drove him in his behavior and his manipulation. Because we know this defendant had a very well-developed ability to zero in on vulnerability, right? Talked about that a little. He zeroed in on Ebony to get after this little girl. He zeroed in on Calissa Kelly for money and for a car, an Ivy van for money. This was a rape, but it was a different kind of rape. It was a capital sexual battery. The victim was a little girl. There is no crime more personal than rape. There's no crime that is more invasive and personally violating than rape. And as I said earlier about the murder, if Felicia had been a 25-year-old woman, this would have been a horrible, horrible case, and this would be a horrible aggravator. This would be a horrible aggravating factor that would increase the gravity of this case, increase the gravity of this crime, if she was a 25-year-old woman. Rape is a uniquely horrible crime by its nature. It's the most personal of crimes, and that's why it's an aggravating factor. The attacker, in this case the defendant, is not just attacking the woman in a rape. He's violating the most intimate and the most personal parts of a woman, of her body. A place that's reserved for special things at special times. In an adult woman, that place is reserved for intimacy. It's reserved for lovemaking. It's also reserved for reproduction and childbirth. There is no more intimate crime than rape. And its violating and invasive nature distinguishes it when you have a stranger forcing their body, not a gun against somebody's head, they're forcing their body with the use of violence or by violence into the body of a woman. That's what makes this case or makes this crime and this aggravating factor increase the gravity of this murder. And of course, that aggravating effect is elevated exponentially by the fact that this wasn't a woman. This was a little girl. Little girls and their private parts. It's a special place for little girls too, even innocent little girls. It's their private place, and they're taught to defend it and to protect it. They're wearing a dress or a skirt to cross their legs, to be ladylike. Even for a little girl, it's the most private part of their body. Felicia wasn't at that point in her life where she was having intimacy with a man. She hadn't even had her period yet, according to Miss Demerson. But this was still a special place in her body. It was going to be used for all those things in the future that I talked about. But this defendant took that away from her. And that's why capital sexual battery, murdering a child during the commission of a rape, is an exponentially elevated aggravating factor. And we go back to what makes children children, is their innocence. She didn't know probably what was happening to her. And we talked to Dr. Downs about that, the confusion. Think about that, the confusion, the pain, the ripping and the tearing of her body and that very sensitive part of her body. She doesn't know what's happening. Why is he doing this? Why is he putting himself in me? Why is he doing this? That adds to the anguish, it adds to the dread, it adds to the suffering. The only sexual contact that this little girl would ever have in her life. And it was one of violence and destruction when this defendant invaded and ravaged and destroyed her innocence in the last seconds and minutes of her life. Does it get any worse for a child? This defendant's not charged with robbery, but he clearly robbed this little girl. He robbed her of her innocence and he robbed her of her life. And that's why this aggravating factor is so weighty. This aggravating factor, if it was the only thing you had in this case, and I just sat down right now, would justify a sentence of death. This aggravating factor alone towers in weight over this suggested mitigation that we've gone through. It absolutely towers in weight over that mitigation. But when you combine it with the other two aggravators, that this little girl died the torturous death, that suffocation and strangulation, the mental anguish and suffering of that, those two absolutely tower over the mitigation. It's not a question of outweighing it. It's a question of blotting it out. They are completely lost in significance to this aggravation. When you assign significance to this aggravation, raping a child and torturing a child while you're doing it, that mitigation just fades out. It doesn't even count in weight compared to the state's aggravation. There's no issue as to whether this aggravation outweighs the mitigation in this case. The only issue is the death penalty the appropriate sentence in this case? Is it a just and fair sentence? These aggravating circumstances, as I've said, they tower because they are giant pillars of proof. They really are. They're like mountains of proof with deep running, deep foundations that support them. The kind of proof, the kind of aggravating factors you can stand on in determining that this defendant should be sentenced to death. The kind of evidence that would support that decision and give you the firm belief and knowledge that it's the true, just verdict in this case. And it allows your decision to be one that you can live with for the rest of the day, for the rest of the week, for the rest of this year, and for the rest of your lives, knowing you did the right, just thing, sentencing this defendant to death. The great 19th century Scottish novelist, Robert Louis Stevenson, who wrote Treasure Island, a book for children, but a great book. And he wrote other books too. Has a famous quote: "Sooner or later, everyone sits down to a banquet of consequences." And this is Granville Ritchie's banquet. Before I end, I want you to consider something that I asked you to consider a couple days ago. Oh, is it on your computer?
Military 701.
That was the last thing Felicia did before she was raped and murdered. That was the very last thing that she did, and as we talked about, she wouldn't have done that if she wasn't terrified. She wouldn't have done that if she wasn't in fear. She wouldn't have made a call to 911 unless this little girl was so scared as to be stared out of her mind. And as we talked about the innocence, the vulnerability of children, their fear is a heightened level of fear, a special kind of fear. This is before this man laid hands on her. And we know that because she was able to get his phone and make this call. Maybe he had fondled her or kissed her or taken her clothes off or started doing something to her, but he wasn't strangling her to death at this point. This is well before that. This is well before the multiple minutes of suffering physically and mentally that she went through with strangulation and rape. But even before all of that, when you're back there deliberating on this verdict, on what the potential, proper, just, right, true verdict for sentencing is in this case, as to whether he should be allowed to live or should be sentenced to death, I want you to consider that call. And consider the fear that that little girl must have been experiencing even before he put a hand on her. And that was just the beginning of the attack. That's just the beginning. In that call, I asked you a couple of days ago if you could hear the fear in her silence. I'd ask you now, can you hear the echoes in that call of the screams that came after that, and the crying, and the pain, and the anguish that reverberated off the walls of that empty apartment?